All right. I hope you had a nice Memorial Day. I did. And I'm finally getting used to the sound of hearing my own voice played back to me from these videos. It's very odd teaching on the computer, but I'm finally getting used to it. In today's video, what I'm going to do is walk you through my expectations for the writing assignment. And I'm going to do that by walking you through some of the course resources that I've posted to the Carmen page. I want to show you how to properly utilize these resources in the way that will be maximally helpful to you. And so the way that I'll proceed in this video is by reviewing several practice problems, and then I'll analyze these practice problems using the methods, rules, and forms of reasoning that I've taught you about so far in this course. My hope is that when it comes to the actual writing assignment, you'll be able to emulate something of what I say here and do well on the writing assignment ultimately. So let me go ahead and share my screen and I'll take you to our Carmen page. Here we are at the Carmen page. Hopefully you can see now week 4's contents. And here's the lecture I've posted from Paulus, the writing assignment, which after consideration, I've decided to make available to you probably by the time you see that this lecture has been posted. So look for that. I've made it available from May 28th until June 9th. So you have quite some time. And I thought that by doing this, you'd have basically this Friday also to ask me any questions you have about the writing assignment. If there's anything that's unclear to you, just drop into that Friday section and we'll talk through any worries that you have. If that time doesn't work for you, send me an email and we'll figure something out. Okay, so here we have a couple of different resources. We have Class Practice OLQ versus Finder. This is a practice problem that I myself have written, and I provided an answer to at least part of the question. The Class Practice OLQ versus Finder is very much like the actual writing assignment, except I would say it's just a little bit harder. And I've also written a model answer to it, and I've posted it thanks to the request of a student from a past semester named Will. So you can all be thankful to Will that you have the model answer now. And then the last resource is this in-class question, probably which I'll go over first right now. Let's pull this up and then see what it says. All right, it says the following events occurred in Utopia, Ohio. And I am going to read this, and it's going to be very boring, so you can skip ahead if you need. The cell phone. As Bob got up to leave the Utopia Transit Authority bus he was riding in, his cell phone fell from his rear pocket onto his seat. Bob left the bus without realizing the phone had fallen out of his pocket. Tom, another passenger, boarded the bus and found Bob's phone on the seat. The phone contained lots of telephone numbers, but no clue as to ownership. Because Tom did not know the identity of the owner of the phone, he placed the phone in his pocket, intending to keep it. After another passenger informed the bus driver that he saw Tom pick up the phone, the bus driver approached Tom and demanded that Tom surrender the phone so that it could be turned over to the lost and found department. Tom refused, left his contact information, and exited the bus. When Bob got home, he discovered his cell phone was missing. He searched for it, but he could not find it. A few days later, Tom received a letter from UTA informing him that although UTA did not know who had dropped the phone on the seat, UTA demanded that Tom surrender the phone to UTA. Tom refused. Several weeks later, Bob retraced his steps and concluded that he must have dropped the phone on the bus. He checked with UTA, which gave him Tom's contact information. Bob demanded that Tom return the phone. Tom refused. Okay. So our first question is, who has superior title to the phone between UTA and Tom? And the second question asks us between Tom and Bob. So let's think about this first question here. Who has superior right to the phone between UTA and Bob? So the way we'd begin to answer a question like this is we'd start off by thinking about IRAC: issue, rule, analysis, conclusion. We first need to identify the issue. Well, the issue is what we've been talking about so far this semester, right? As between the finder of lost property and the owner of the locus in quo, who has superior title to something that's found. That's basically the issue. Now, let's think about what our rules are. Since we're in Ohio, we can assume that we're applying the American rule, right? The American rule is that the finder of lost or abandoned property acquires superior title to the entire world except for the rightful owner. But if the item is mislaid, superior title goes to the owner of the locus in quo. So critically in America, the way the item was lost will be dispositive. So now we need to scour through the facts to find out how this thing was lost. Well, let's see what happens. It says in the facts that the cell phone fell from Bob's rear pocket onto the seat. Bob is the original owner. Recall that there are three categories of property that could be found. There's lost, mislaid, and abandoned property. And in a question where you answer something like what's being asked of you here, you'll need to define all three categories. So lost property is property from which the loser has been unintentionally dispossessed paradigmatically by dropping. Mislaid property is property that is intentionally placed somewhere and then forgotten about and left. And abandoned property is property which, from the conditions under which it's found, provide evidence to a third party that the previous owner intended to permanently relinquish all possessory interests in it. Now, which one of these best fits the facts? This is what we're doing now when we think about our analysis section. What I've just told you, the American rule and the categories of property, that'll all be slotted into your rule part of an IRAC analysis. But now let's think about the analysis. Let's find some particular facts from what I've just read and tie them to the rule. Well, it says here in this part that I've highlighted that the cell phone fell from the rear pocket onto the seat. Recall that lost property is property from which the owner has been unintentionally dispossessed paradigmatically by dropping. So it looks here like this property will be considered lost because it was dropped. In other words, Bob was unintentionally dispossessed of this property. He lost it in a manner he knew not how or when. It wasn't mislaid. He didn't put it on the seat and then forget about it. And he didn't abandon it. Someone who came along to the bus just by seeing a phone on the seat would not rightfully infer that the previous owner intended to permanently relinquish any possessory interest in that item. Now, somebody who found a cell phone in, say, a trash can might reasonably make this inference, but you wouldn't reasonably make this inference when you find a cell phone on a bus seat. For these reasons, it looks like the cell phone is lost. That's our intermediary conclusion. Okay, now let's tie it back to the rule even further. What does the rule tell us about lost property? Well, under the American rule, a finder of lost property acquires superior title to the entire world except for the rightful owner. And so, who is the finder in this case? Bob is the loser, or the original owner, to put it more sanguinely, but Tom is the finder. Tom doesn't seem like he has pure motives. He refuses, by the way, to take any kind of action that is likely to eventuate this property being reunited with the rightful owner. So he's not a good guy, at least that's what I'm making of the fact pattern here, but he is the finder, and so he has certain rights under American law. And because Tom is the finder under the American rule, he has superior title to UTA. The way we can think about this is title is relative. So recall back to Armory versus Delmiri, where the chimney sweep finds a ring in the chimney and takes it to a jeweler, a goldsmith, to be appraised. Well, the chimney sweep is the finder, and the jeweler is even further down the chain of title. And it's not like you can just go to somebody's house and find a ring in their chimney and expect to have the best possible title to it. That's kind of a question that's still up for debate, given all the case law we've read, right? But one thing's clear, the chimney sweep had better title to it than the goldsmith did. That's all we're thinking about here. In this question, we're just asking whether Tom has better title than UTA. Of course, Bob, as the true owner, has the best possible title to it. It's his cell phone. He's the rightful owner. But as between Tom and UTA, who has better title? Under the American rule, Tom has better title because he's the finder of lost property. Now, in a previous class, what I did was I put this question on the board and I answered it kind of in real time in front of the students by typing this answer. And so you might read it now and you might see that there are some typos in it or something like that. It's because I was trying to write it under time constraint. And as an example of what one could do when one was under time constraint, because this is a bar question that was given on the Ohio State Bar in February 2012. And so those sitting for the bar exam at the time would have had to have answered this question under time constraints. And so I did it in front of my students under time constraints as well. And you might just see how I approach the question, and you might model your own answer off of it if you're so inclined. There's a second question that I think we can analyze now. It's question 2. Finder is employed as a janitor by hospital. During his shift, Finder found a woman's purse containing $500 in cosmetics laying on top of the patient checkout desk of the hospital. The purse did not contain any identification. Finder turned the purse and its contents over to the lost and found department of the hospital. Hospital contacted current and former patients and employees, the police, and local media about the purse to see if anyone could identify the owner. After a year, no one had claimed the purse. Finder claimed that the purse and its contents, including the $500, now belonged to him and demanded that the hospital release it to him. Hospital refused to do so. So the question that we'll answer now is, as between hospital and Finder, who has superior title to the purse and its contents? We'll approach this question the exact same way we did the previous question. Let's remember IRAC. Our issue is, as between a finder and the owner of the locus in quo, who has superior title to a purse that was found on the checkout desk of a hospital. That's basically our issue statement. Here I've done things a bit differently. I haven't begun my answer with an issue statement. I've begun with a conclusion. This is acceptable too, but it's a little bit of an advanced move. You can model your answer off that because this question itself kind of is the issue statement, isn't it? And so given that oftentimes the question you're asked to answer is the issue statement, it seems kind of weird to repeat it directly after the prompt. That's probably what I was thinking when I just began with the conclusion for a nice blunt introduction to this writing. But regardless of whether you begin with a conclusion or an issue statement, immediately after one would expect to find the rule statements, right? And so what are our guiding principles that we can appeal to in order to solve this problem? Well, the American rule is that the finder of lost property acquires superior title over the superior title to the entire world except the rightful owner. But if the item is mislaid, the owner of the locus in quo will prevail over a finder. And so we again have to recall our definitions of lost, abandoned, and mislaid property. Obviously, this thing isn't abandoned because one wouldn't infer from finding a purse on the counter of a checkout desk that the previous owner intended to permanently relinquish any possessory interest in it, right? Maybe if you found a purse in a Goodwill or something like that, you might infer that the previous owner intended to permanently relinquish possession of the purse. Maybe you find money in that purse. I'm not sure what would happen in that case. But for here, it just seems like the facts are screaming to us that the item was not abandoned. So the real work is going to be trying to figure out whether this thing was lost or mislaid. So lost property is property from which the owner has been unintentionally dispossessed paradigmatically by dropping. And mislaid property, in contrast, is property that is intentionally placed somewhere and then forgotten about. Now, if the purse was on the ground, that seems to be a little bit more conclusive. We would be inclined to think that the purse was lost if we found it on the ground because it's possible to drop something onto the ground. It seems rather implausible to me that one would drop a purse onto a checkout desk. The most likely explanation of the facts, I think, is that somebody intentionally put the purse on the checkout desk, perhaps even while they were checking out, and then walked away. For these reasons, it looks like the purse was intentionally placed where left and then forgotten about. Because this is the case, the purse is most likely going to be considered mislaid property. Now let's tie the status of the purse as being mislaid back to the rule. Recall that the owner of the locus in quo will prevail over a finder if the item was mislaid. Why? Because America thinks that the owner of the locus in quo will be in a better position to reunite mislaid property with the rightful owner. Regardless, the purse here looks mislaid, and under American law for mislaid property, the owner of a locus in quo will prevail over a finder. And so in this case, the hospital will therefore prevail over the finder. I've talked you through this, but you can see the way I've written this on the fly if you want. It's all here in the document. Okay, let's move on to a different resource now and think about this together. Perhaps we could think about this class practice OLQ versus Finder. It's a question I wrote to be a little bit trickier, and let's think about it together. Okay. Henry Handyman is hired by Bob Fee to repair a shed located on Bob's property. Bob owns approximately 30 acres of land in Southwest Ohio, and he uses the land primarily as a hunting lodge during the fall hunting season. Henry went to Bob Fee's property to repair the shed. The roof of the shed was in pretty bad shape and would require 2 days of work to fully repair everything that needed to be fixed. On the first day, Henry took his lunch break while walking through the woods of Bob's property. While he was walking, Henry discovered a pile of trash bags surrounding an overturned ATV. The ATV was about a quarter of a mile away from the shed. After examining the ATV, Henry realized there was only a very small mechanical problem with the ATV, and so after he finished working on the shed for the day, he used a winch to drag the ATV onto the trailer of his pickup truck. He asked Bob about the ATV, and Bob had no idea that the ATV or the trash were on his land, and Bob was upset that someone had used his land as their personal site for dumping garbage. Henry was able to fix the ATV with just a little bit of effort, and he sold it to a friend for $1,000. On the second day of fixing the roof, Henry noticed a laminated envelope stapled to the corner of the roof. Because he was curious, he found a letter that read, "Dear Beth, I hope you never have to sell these, but if you do, Jerry Walker at 988 Wisconsin Avenue will give you a great price." In the envelope was an 1892 Micro O barbered $50 and almost uncirculated condition. The person referenced in the undated letter seemed to have died in 1972, according to a local newspaper. Henry took the coin and sold it at an auction for $25,000. Henry told a friend about his great fortune, and word eventually got back to Bob. Bob's attorney demanded $26,000 from Henry, $25,000 for the coin, and $1,000 for the ATV. To how much money is Bob plausibly entitled? Would the results differ if the case happened in England as opposed to America? All right. So how are we going to tackle this first question about the ATV? We'll do it the same way with IRAC. What's the issue? The issue is whether the finder or the owner of the locus in quo has better title to property that's found. What are our rules? What are our categorizations of property that we could play with here? Well, first we have lost property, property with which the owner has been unintentionally dispossessed, usually by dropping. We have mislaid property that's intentionally placed where left and forgotten about. And then we have abandoned property, which, by the conditions under which it's found, provide this evidence that the previous owner intended to permanently relinquish any possessory interest in the item. Let's think about the ATV first. To me, the ATV looks like it's abandoned. It looks like it's abandoned because it's found in this pile of trash. And you might think that what happened, you might reasonably infer that what happened is that somebody dumped a bunch of trash onto this land, and that when they were dumping the trash, they dumped the ATV out with it. Now, you didn't think this for certain. There could be alternate explanations of how it got there. Maybe the guy was riding the ATV and it got away from him, and it continued to go without any rider, and it went through the woods and ultimately landed on its side. And he's been looking for his ATV ever since. The facts are consistent with that kind of thing, but it isn't the most plausible explanation to me for some reason. It looks to me like what's happened is that somebody's just dumped an ATV with a dump truck and a bunch of trash onto land. And the ATV, as a result of that, is on its side. It's broken, by the way, so it looks like the kind of thing that somebody might throw away if they thought that there was a serious mechanical problem with it and it wouldn't be easily repaired. A novice might think that, of course. So, for those reasons, it looks to me like the ATV is abandoned. Now, what's our rule for abandoned property? The finder of abandoned property will prevail, by the way, over the owner of the locus and quo in America. And because Henry Handyman is the finder of abandoned property, it looks like he'll have better title than Bob Fee. And for that reason, it looks like Henry Handyman will prevail under American law. Second question is equally perplexing. We have this micro O Barber half dollar that's found in an envelope. Let's think about our categories of property again. Is it something from which the previous owner was likely unintentionally dispossessed by dropping or some other way? Not plausibly. It's found in this crevice, right? Stapled to the top of a roof. Is the property mislaid, intentionally placed somewhere and then forgotten about? That seems like an apt description. But think about it. Is the property plausibly abandoned? Is it clear from the context in which it's found that the previous owner intended to permanently relinquish possession of it? It does seem like that description is apt because this guy, Jerry Walker, is trying to give it to this person, Beth. So he's trying to permanently relinquish possession of it, but he's trying to leave title with somebody else. I'm not sure if this is a legally relevant difference, but to me, it looks different than a case in which you find trash in a dumpster or something like that. It's not merely like he threw the coin away, and it was apparent from the condition under which it was found that the previous owner intended to get rid of it. It looks like he's trying to give it to somebody. It looks different than the way in which you might find trash. So it's tricky. We don't really have any information from the law about what would happen in this kind of a case. But I wonder if this property would be considered mislaid, intentionally placed and then forgotten about. Or, yeah, I'm not sure. I'm not sure. So here's where you kind of get to put on your lawyer hat and you get to try to make an argument about whether the property is more plausibly abandoned or mislaid. And whatever you think of as the answer to this question is going to really make or break the case. Because if you think the property is mislaid, you'll think that Bob Fee has better title to it as the owner of the locus and quo, because under the American rule, the owner of the locus and quo will prevail over a finder if the property is mislaid. However, if you think the property is plausibly abandoned, Henry Handyman will again prevail, because under the American rule, after all, a finder of lost or abandoned property prevails over the owner of the locus and quo. Okay, so far so good. Let's think now about how the results might differ if we don't apply the American rule, but opt instead to apply the English rule. Let's get the English rule on the table because I didn't talk about it in the previous question because it wasn't relevant to the case that happened in Ohio. And I guess it isn't really relevant here either, but it's a good time to exercise our newfound knowledge, right? So the English rule is that the finder of lost or abandoned property will prevail over the owner of the locus and quo if the locus is public. But if the locus is private, the owner of the locus and quo will prevail. And remember the important fact that English law does not recognize the existence of mislaid property. They'll consider anything that's mislaid lost. Okay, so now, rather than analyzing the way in which the property was lost, we need to think about the premises themselves. We need to think about the locus. Now, what are we to make of the ATV? Is it on a public locus or is it not? Recall that in the previous lecture, I told you that a public locus, well, really a private locus, is defined by the manifestations of intent to exclude other people. If you manifest some kind of intention to exclude people from being there, then it looks like the locus is private. And if you don't manifest that intention, and it's rather easy to get to that place, then the more the property looks like it's public. Now here, it looks like there's a certain part of Bob V's property that's pretty easily accessible. And it's easily accessible, maybe because Bob hasn't taken many pains to exclude people from that location. In fact, it's so easily accessible that apparently a dump truck is able to drive here, dump trash all over a certain place, right? So here it doesn't look like Bob has taken that many pains to exclude the people from this location, though given by his outburst, you might think he would take such pains in the future. But for now, it looks like the locus is a little bit more public than some other places of his property, such as his house or maybe even his shed, which we'll talk about in a moment. So I wouldn't be surprised if this is a public locus. And because it's a public locus, the finder could prevail for a public locus. Now let's think about the shed. The shed to me seems like a place where the public generally is not allowed to be. And it seems like people do exercise degrees of control over their shed. There's often doors on these things which are lockable. Just a general inference about the way people usually treat their sheds. They aren't these public places that people can come in. In fact, if you found someone in your shed, it would be quite alarming and you'd probably call the police, I think. So for those reasons, I think that sheds look a lot more private than these fields do. And so it's more plausible to me that the shed would be considered a private locus. By the way, this case kind of mirrors South Staffordshire Water Company versus Sharman, which the court found that the water company exercised a high degree of control over the pool and that the public was generally excluded from this locus. So much so that when they hired someone to come to the premises to clean the pool, the court found for the water company over the finder, saying that the pool was considered private because the water company exercised this high degree of control over Minster Pool. Now here it looks like Bob Fee is inviting Henry Handyman to his property for the same reason of doing some repair work. And so much like in South Staffordshire Water Company, the water company exercises this degree of control over the pool. So too, it looks like Bob Fee will likely be considered the owner of the locus in quo who is exercising a degree of control and manifesting an intent to exclude the public from the shed, such that a worker that's expressly brought there for the purpose of making the shed better is trumped by his rights as the owner of the locus in quo. So I think that basically here, with the case of the micro O, you'll basically just say that South Staffordshire Water Company is analogous here, and for that reason, it favors the owner of the locus in quo over a finder, because the locus is private. Okay. So far, we've looked at two practice problems. And now I'll show you our actual writing assignment that I will give you until June 9th to complete. Okay, so I'm not going to read this. That would be very boring. You have it on your own. But basically, I do want to tell you about the questions that you'll be asked to answer. So you'll be asked to answer whether a finder or an owner of a locus in quo has superior title. And then you'll be asked to ascertain whether a finder or someone even further down the chain of title has superior title. And I'd like for you to take just a bit of caution when you answer this question. I'd like for you to think about the shopkeeper in Bridges versus Hawksworth. So in that case, recall Bridges goes into Hawksworth's shop and he finds 65 pounds of notes on the floor. And the first thing this finder does is he hands them over to the shopkeeper and says, let's try to find the rightful owner of these notes. the first thing he does is give them to somebody else. And the court found that just by giving them to somebody else, just by handing them over as soon as he found the notes, he didn't relinquish any possessory interests he had in the notes. And what were his interests? Well, his interests were those of a finder. So somebody who finds something is still a finder regardless of what they do with it after, unless they clearly abandon it. You might say if you just found the notes and you had some sort of conclusory language to accompany that, like, I don't need these, I don't even want this money. You're more or less explicit in your abandoning of the notes. I'm sure you could somehow relinquish your possessory interest in those notes as a finder. But notice that didn't happen in Bridges versus Hawksworth. And I'd like for you to think about whether that result applies when you answer question B, because a lot of students will get this wrong. Now, here's kind of a softball question. Will there be any people other than this finder or someone even further down the chain of title who have superior title to the GoPro? And then the last question, because this case does happen in England after all, and so you'll be applying English law. In question D, I throw a curveball at you, and I make you do the whole thing all over again, analyzing instead American law instead of English law. So A, B, and C can be relatively short paragraphs, but D here should be relatively lengthy because you have to redo the entire analysis under American law, right? So far, so good. You are allowed to copy and paste the rule that you write in question A into B and C. So if you say that the English rule is that the finder prevails over a owner of a locus in quo if the locus is public, and you say that the owner of the locus in quo will prevail over a finder if the locus is private, go ahead and just copy and paste that to A and B and C if it's relevant. No worries on my end if you're just copying and pasting a rule that you've already wordsmithed. Same thing for question D. You'll have to redo the analysis, and so you might have to copy and paste the American rule more than once. However you choose to do that is fine. You can be repetitive and iterative in your answers here. What I'm looking for is a thorough analysis. And I find that most of the students who do this will take at least 1,000 words to do it well. I've seen some people go under this word count and still do a good job, but it's rare. And I've seen some students go considerably longer than this, and they say things that are duplicative and irrelevant and erroneous, and it doesn't help them. And then I've seen people who have written far above this word limit and have done so in a masterful way. And I've ultimately recommended a few students who wrote way too much for this assignment for law school. And I've had, I've seen them go through periods of success. Actually, the last student I had that really went above and beyond on this assignment is now starting at OSU Law, which is good for him. Anyway, I'm not going to talk about my previous students. Those are just some of my preliminary expectations for the writing assignment. And I'd like to discuss these further with you if you have any questions about them on Friday. So I think I'm going to end the video here. Hope it was useful to you. Hope you found out what some of my expectations were. And now you can refer back to the course materials on Carmen and see how I've approached these problems. And you can emulate my writing in the way I've approached. And ultimately, what you'll be doing is emulating not just me, but legal scholars and academics everywhere. And this will be kind of your immersion into legal reasoning as it would actually happen in law school and in a law firm. So I hope you enjoy the writing assignment, and let me know if you have any questions.